Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about is filing an objection and protective order for certain documents that are requested as part of a deposition in a divorce case. And a deposition is basically a meeting where the attorneys and the parties in a divorce, they sit down outside of a courtroom, but they have a court reporter or stenographer present who's taking a transcript down of the questions that are asked. And one attorney will ask a whole series of questions of the opposing party relating to relating to the cause of the breakdown in the marriage, the financial background in the divorce, etc. And if you want to know more about depositions, we have a couple of videos that talk about the deposition process in a divorce. But along with the notice of deposition, which is a document that is sent to the opposing attorney, basically saying, I'm taking your client's deposition on so-and-so a date, attached to that notice of deposition, there will often be a Schedule A, which is a whole list of documents that the attorney wants the opposing party to bring with them to the deposition. Usually it's financial documents such as bank statements, credit card statements, a financial affidavit, etc. But sometimes an opposing party may request documents that you feel are inappropriate discover requests in a divorce case. And if that is the case, then you're going to want to file an objection and protective order, motion for protective order in response to those documents that are inappropriately being requested. So I'm going to share my screen and show you some practice book sections or a practice book section along with the sample motion. So the relevant practice book section is 13-5, which is the protective order section. And it says that upon a motion by a party from whom discovery is sought and for good cause shown, the judicial authority, so a judge, may make any order which justice requires to protect a party from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following. So a court might order, the most simple thing is the court just orders that, the other side can't have discovery. They might order that discovery may be had, but only on specific terms and conditions, including a designated time or place. So basically specific terms or conditions that the judge lays out for which, discovery is provided to the other party. That the discovery may be had only by a method of discovery other than that selected by the party seeking discovery. And there, there's a whole list of additional kind of provisions in this section, but the most common is just that this is the discovery not be had. So that is the relevant protective order section. And then we've got some other videos that talk about the relevant discovery objection practice book sections. But let me just show you from a practical standpoint what you have to put together in response to a deposition notice that requests inappropriate documents. You're basically going to want to put together a motion that looks like this, and you'll be able to get a copy of this motion if you visit our website. And it's, plaintiff's motion for protective order and objections regarding defendant's notice of deposition dated so-and-so. So, you just insert the date of the deposition notice. And then you just put either pendente lite or post-judgment. Pendente lite is if it's while a divorce is going on, or post-judgment is if, the deposition is relating to, motions that are filed after a divorce is over, such as a motion to modify or a motion for contempt. So the heart of the motion will say, pursuant to practice books 13-2, which is a discovery practice book section, and 13-5, which is the section I just showed you. The plaintiff respectfully objects and moves the court for a protective order with respect to documents, with request to document requests contained within defendant's notice of plaintiff's deposition dated so-and-so a date. The plaintiff respectfully represents as follows. And then you give the court a little bit of background about when the notice of deposition was served, when the deposition is supposed to take place, etc. And then you're just going to put that the plaintiff objects and moves for a protective order with respect to requests found in the Schedule A attached to the defendant's notice of deposition. And then what you're going to want to do is just put the actual requests. So you list the text of whatever is requested by the opposing party, and these are just some random samples. And then you put whatever the objection is. You put that objection immediately after itemizing each request. And then at the end, you just say that the plaintiff's objections as set forth above to the request as set forth in Schedule A of the notice of deposition. You're asking that the court sustain that and that a protective order shall be entered with respect to those requests. So that is pretty much it. Those are the basics on how you deal with a situation of an opposing party requesting inappropriate documents at a deposition. And if you have any other questions about this, feel free to call our office. We'd be happy to answer any questions.